Thank you, everybody. Thank you, Max. Thank you, Francois. Welcome back for another exciting deep dive into the legalities around firearms and self-defense and what the law says. Everybody, if you haven't seen the previous episodes, I suggest you do that. Today, it's going to be I'm going to leave it open to the two legal eagles. They'll carry on and dive deep into all the definitions behind it. The shooting has now taken place. The police have now done what they should do. And I'm just sitting and waiting. And you will now see Max and Francois in action, diving deep into all the legal definitions and saying a lot of things like Julius Caesar did, like Veni, Vidi, Vici, and Alia Jacta Est, and all that stuff that you read in the Asterix books. So, guys, thank you once again for being here.
Yeah. See if he's barking. Yeah.
Looking forward to the chat between the two guys, and yeah, let's dive into that. So I'm going to leave it open to Max. Give it over to Max. Thanks.
Great. Dion, again, thank you very much for having us and for hosting us. It allows us to listen to the sounds of our voices, which we both seem to adore. Francois, dankie vir jou tyd. Thanks for joining us again. I always enjoy these discussions, especially the technical legal discussions with you. Yeah, I'm going to try and lead the agenda in a sensible fashion and let you give us concise data to the greatest extent possible. And we'll probably end up, going down rabbit holes, but I'll try and avoid them as far as possible. So to start off, you've now been in the defensive shooting, or let's say the shooting has taken place and SAPs have now investigated, and there are certain considerations or offenses. Now, just to rewind a little bit into what potential charges exist or what criminal charges can arise from the potential or the use of potentially lethal force. Obviously, another human being is either injured or incapacitated or deceased after that kind of shooting, or none of the above. But I mean, the first and foremost focus, I think, today is to distinguish between the different types of common law offenses, and then always keeping in the back of your mind that there's a distinction between a common law offense or common law crime and a statutory offense, which is born or breathed life into by legislation. So legislation says some or other act says you may not do X or you may not do Y. And if you do X or Y, that is an offense in terms of the act. Whereas our common law, just to refresh memories, is essentially an adopted, I think it would be safe to say that it's an adopted series of laws from our Roman Dutch law and British common law, given the very interesting history of South Africa. There were laws that were adopted and policies that were adopted and developed by our courts over the last couple of centuries, such as the crime of murder, the crime of culpable homicide, which is, again, I'm going to leave it to Francois to define those concepts, but I think it's important to note that the pointing of a firearm would be a statutory offense, whereas our, let's say, the codification of our laws are in different places. So our law reports, Francois, you can add on if there's anything that I'm missing, but typically case law develops the different crimes and offenses against them in the common law sphere, and statutory offenses are on a technical basis or dealt with on a technical and ad hoc basis as and when they arise, to show whether that conduct, so there was positive conduct which breached a prohibition. So if an act said don't do something and the person did something, or where the act said you must do something and you failed to do that, that would be essentially negative culpability. That would be the right way of phrasing it, Francois. And I think what we're going to start with today are the typical offenses that can arise. Or rather, let's say common law charges that can arise. I don't want to go down the statutory offenses hole because that's pretty simple. Either you did what the Act says you must not do, or you didn't do what the Act says you must do. So that's quite straightforward, and the Acts speak for themselves. But in the common law, a lot of people think that like murder is somewhere in an act, the concept of murder or the defenses to it, private defense or culpable homicide. It's not something that's codified in a piece of legislation. It's codified in our law reports, it's codified in our case law, and it's codified as authority, which has been developed over the years and read together over a very broad series of cases pertaining to the different aspects of each crime. So starting out with, I think, if a person dies after a shooting or a defensive shooting, and the charges that would then be considered would be either murder or culpable homicide, being the causing of death of another person and or another human being. And I think we'll get into that from Francois' side now, into the definitions of it and the defenses to those charges. If a person is injured, it could be attempted murder, it could be assault to cause grievous bodily harm, with the intention to cause grievous bodily harm because a weapon was involved. Yeah, there's a very broad array of charge or I think, charge considerations that can be stemmed together and put together by the prosecutor in making that decision, which could also be accompanied by several statutory offences. Francois, you'd agree that yes, there might have been an injury or an attempted murder, but there was also then pointing of a firearm and discharging a firearm in a public place, and a series of other statutory offences that may flow in the same case or under the same case number for investigation and obviously pursuit by the NPA or the prosecutor in that set of circumstances. So, Francois,
sorry, Matt, can I ask something? Because I know people will ask here that the question will come, but what will they accuse me of? Is there a simple answer to that or not? As you
no.
said, it may this and it may that.
Circumstantially, or circumstances will dictate what the prosecutor. So the prosecutor is very afraid with the definitions of the, let's say, the requirements for common law offences or crimes, such as murder or culpable homicide. So immediately, if certain facts string together and that the investigation in the docket shows that, this is what happened, and this is, these are the facts, or this is the evidence already before, the prosecutor will draw an inference, or the prosecutor will use essentially its discretion to say, right, I believe that from what I've read and from witness reports, etc., or from what's been gathered, it appears to me that this was a murder, or it appears to me that this was a negligent shooting, or a negligent discharge of a firearm that injured somebody or caused their death, or that kind of thing. And from there, it will start to roll. Also, this guy didn't have a license for this firearm that he used, that he discharged. So that means that already Section 3 of the Act, of the Firearms Control Act, has been contravened, which would then also be a statutory offence on the same bar. So there, the little list of charges start to mount, and that prosecutor starts to formulate the case. And then obviously the prosecutor can also, in the face of evidence and with a good attorney and with a good attorney's insight and input right at the early non-representations phase, be persuaded otherwise, is not to prosecute, that, this was obviously a good shoot, or negligence wasn't a contributing factor here, or whatever it might have been, so it's a very stressful period for anybody that's been in a defensive shooting, because there's a lot of consideration and a lot of contemplation that needs to take place. Take anything between 6 months to 2 years to however long for a investigation really to get to a prosecutor to making the decision of whether to prosecute or not, on to nulla prosecutors, to a decision not to prosecute, and then a decision to prosecute is conveyed, right? Charges are,
Yeah, what often happens, Max, I think sometimes it's quite straightforward at the outset, and they decide to charge someone or not to. But the proper investigation especially when someone is deceased, typically takes quite a long time. They often wait for the medico-legal examination to be well. That's concluded quite early, typically, but they wait for the report on that. So for the post-mortem report, essentially, to be prepared. That often involves, all kinds of histology or toxicology tests and this and that. Not necessarily where you have a let's call it a shooting, whether it's a legitimate defensive shooting or not, because then quite often the cause of death is quite straightforward. But doing the paperwork, getting all the witness statements, doing ballistics on firearms that have been seized from the scene, all of that takes many months at least. And there might be various other reasons also where it is delayed. But yeah, you can expect whether you are charged early on or whether the decision on charging you or not, prosecuting you or not, only takes place at a later stage. The process does take very long. Whether that's the let's call it the pre-charging process, or the later on the pre-trial process, because obviously the court process is on for quite some time before you actually get to the point of starting with your trial. Prior to that, there's probably an arrest, there's a bail application, there are postponements for further investigation, there's this, there's that. Quite often the matters get withdrawn or struck from the court roll long before a trial even starts. Based on the fact that the investigation is not going anywhere, or the prosecution at the outset was willing to proceed with the prosecution, so you had to apply for bail after having been arrested, and then later on, based on further investigation and information that is forthcoming, they decide not to proceed with the prosecution, or subsequent to representations being done by your legal representative as to why it would be justified to withdraw the charges. What happens sometimes is you might be arrested, and then at the very first court appearance, that's the first time when a prosecutor actually sees the docket and sees the information or allegations contained in the docket. And quite often at that stage, they decide not to enroll a particular matter because they believe there's not a sufficient case made out as yet to keep someone in custody or to force them to apply for bail. And then they might not enroll it at that stage and then decide to enroll it later on. But regardless of what shape or form this takes, it is a lengthy process, and you can bet that it's going to be not months but probably years before the matter is concluded, depending of course on what happens. If a person was to want to plead guilty at the first instance, it might be something that only takes a couple of months. But it's quite a lengthy process, and you're going to be in for quite a ride if you find yourself on the end of the accused in a criminal trial where you are facing either a charge of murder or culpable homicide, or whatever other offense, whether it be a statutory offense like you mentioned, which comes out of a statute otherwise which is written in an act of parliament somewhere, or whether it's a common law offense like murder or culpable homicide that, as you mentioned, is basically something that has developed over hundreds of years in the Roman law and in the Dutch law, and we basically then inherited that. And over the years, as you mentioned, our courts and our academics have developed those common law offences further. So it's not to say they are exactly the same or approach exactly the same as they would have been centuries ago, but you don't find a specific act of the Parliament of South Africa dealing with the charge of murder or culpable homicide. You find that in, as you mentioned, our common law, and our courts then develop the common law by interpreting these academic works in a certain way. But what you can accept is that most of or many of the common law offences, at least, have been developed and studied to quite a significant extent, because we're talking about things that are coming for hundreds and hundreds of years. So it is quite clear how our courts will define and approach a charge of murder or a charge of culpable homicide, and what exactly the legal test will be that is to be applied to decide whether or not you are acquitted or convicted.
I appreciate that. It's exciting for me to talk about this stuff because I don't practice it, and I had such a passion for the criminal side of it, academically. And I think one of the exciting parts now is getting into the, let's say, getting into the definitions again, and looking at, or basically deconstructing the different, the different common law charges. So I think let's dive into that, and that's the big point of interest today, is the charges of murder and a charge of culpable homicide. And I think we can start with the charge of murder, and if you could give a nice academic textbook definition of it, and then we can sort of walk in through the different aspects of it. So I think our legal programming, or from a law student's programming and studying things, it's a sentence, but it's comprised of 4 or 5 elements. That it's the same with
Yeah.
the law of delict. If you describe a delict, it's straightforward. But if you go into each compartment within that description, and each element of the delict, those elements must all exist for a delict to exist. And it's the same with a crime, or it's the same with a charge. All of the elements must exist of the definition for it to comprise that crime or that offense. So, Francois, please take it away and tell us a little bit about murder and the charge of murder in the Republic of South Africa.
Sure. So the definition itself, as you mentioned, is quite short, but quite complicated if you unpack it. But essentially, any textbook definition, or any good textbook definition, would be that murder is the unlawful intentional causing of the death of another human being. So if we unpack that in basic terms, it must be an unlawful killing. In other words, there is no valid defense present. We'll deal with some defenses later, but let's say the defense of private defense or self-defense, that I think we are all familiar with, at least in principle. That would exclude the unlawfulness of the killing if you were to do it in legitimate private defense. So it needs to be unlawful. It needs to be intentional. That is basically what we call a subjective test, meaning the court must determine what you as an individual, what your subjective frame of mind was, and what you actually aimed to achieve.
We've got number one is unlawful. So number one is the unlawful act.
Unlawful,
number
intentional.
2 is our intentional. Yeah.
Intentional. Let's just deal with the elements quickly. It's the unlawful, intentional causing of death of another human being. All right. Yeah. So I think let's deal with them in order. The unlawfulness is basically to say that it is in contravention of the law. In this case, the common law principle that prohibits murder. There is no valid defense present that could exclude the unlawfulness. It is intentional. That means that you had the subjective frame of mind, and you meant to actually kill the person, and we'll unpack that a bit further now.
You comply with one of the 3 types of intention.
Yes. The element of intention also deals with the fact that, and that's quite a Pandora's box in itself, but it also deals with the fact that you must be compos mentis. You must have, legally speaking, cognition and coordination, which means that you have the ability to distinguish between right and wrong, and you have the ability to direct your acts in accordance with that. All right, intentional causing of death. That sounds quite straightforward, but in practice, it can be quite difficult to determine whether that which the accused did is actually what caused the death.
Sometimes is this where we had that novus actus interveniens and
yes,
those types of considerations.
All kinds of theories as to when you determine what exactly whether there's a causal link, or whether there is proper factual and legal causation between the act and the eventual death of the person. And
that was very
you can imagine, depending on the circumstances, that is not always quite so straightforward.
No, it's very interesting, because I remember there was a mob justice matter that we dealt with. It was during the 90s with the PAC violence, I think, in Natal. And one man was stabbed by several, by several attackers, if I could put it that way, or perpetrators. And the naduitse ondersoek, the post-mortem, showed that there was a final death blow, which was a puncture wound to the heart and lungs.
Yes.
And the other men had stabbed him, they were charged with attempted murder.
Yeah, yeah.
Whereas the guy who dealt out the death blow, who punctured the lung, was charged with murder because it caused the death of the other, the other human being, that human being. Yeah, yeah.
So in that instance, you had a post-mortem saying that the actual cause of death was that specific stab.
Yes.
And on that basis, let's say, I'm not familiar with the case, but that person was convicted and the other ones were convicted of attempted murder. But in many instances, typically in a let's call it a gangbang scenario, you wouldn't necessarily be able to determine that. So that's where we have the principle called common purpose.
That's right.
The doctrine of common purpose, which basically says that if more than one person or a group of persons were actively involved in a certain act and all reconciled themselves with the probable or likely or possible even result of that, then that causing of death element can be basically tied to all of them.
I remember that comment. So I think on this one, why it was so distinguishable, I think it could have also been a beating and not stab wounds or something. I just remember it was a case that was dealt with hypothetically with the gang violence, and there was a distinction between the common purpose or the pinning of common purpose onto perpetrators in a mob, in a mob related scenario, and then there was also sometimes it can be clearly determined who caused the death, whereas the other wounds,
you have robbers running into a store. Only one of them is actually well, let's say for argument's sake, they all have weapons, but only one is actually shooting at people, and a person is then killed, and then you'll find that all of them are charged with murder. And on the basis of this common purpose doctrine, to say they all associated themselves with the act and they all had to foresee this result. Now, there are certain defenses, obviously, to that, where you can say that, now, I was part of the robbery, but I was never told, or I never had a reasonable expectation that we're going to be shooting anyone, and then it becomes quite complicated. There's also what we used to have a principle called Versari doctrine, which means that if you are involved in an unlawful act, all the results of that act, whether you intended them or took part of them in them or not, are basically laid on your shoulders. Now that principle doesn't apply anymore. So they still need to prove a causation or a causal link, both legally and factually, between the act that you perpetrated and the eventual death. But there are ways, in instances of common purpose, the only doctrine that I'm aware of where they can basically ascribe that to you in the absence of being able to prove the whole chain, if we can call it that, is common purpose. So and then so that's obviously the causing of death element, and then the last element is of a human being. Now that's actually the most simple one. We all know what a human being is, but where it becomes specific is, for instance, if you shoot a dead person, you are guilty of the statutory offense of violating of a corpse. I'm not even sure whether, I'm sure there is a common law offense like that. I'm not sure whether we have it.
Yeah, but I think it was, I think it did become a statutory.
But be that as it may, so you can actually insert the words "an alive human being" or a person that was alive at the point where you committed the certain act. So those are basically the elements. Say it's the unlawful killing, meaning there's or it's unlawful. There's no valid defense to it. For instance, we don't have that in South Africa, but in other countries you have assisted suicide. So that the doctor would be causing your death, but it would not be unlawful because the law makes provision for that. Intentional, we dealt with that, deals with your subjective frame of mind and whether or not you're compos mentis and things like that. And then the killing is obviously, which we discussed now, whether you are the actual cause of death and of a human being. Something that you also obviously often see is, let's say there's a motor vehicle collision, somebody is seriously injured, and then that person dies as a result of a paramedic not doing something correctly or properly when they transport the person to the hospital, or he gets to hospital and it's a government hospital that doesn't have beds and he doesn't get timely attention and now he passes away, it can become quite difficult to determine what the actual cause of death was, and whether there is factually and legally speaking a link of causation between your initial act and the eventual death. And sometimes the time between those things can be a long time. You might shoot someone and they are in hospital for weeks and months and then pass away due to complications later on. So that can become quite difficult, but that's essentially in a word, those are the 4 elements of the offense. The one thing that I think we should just deal with is intentional. Now, intention can exist in different forms. We have essentially 3 forms of intention. To use the Latin, like Dion did say we were going to, and I thought perhaps we weren't, but there's no way to stop from using some Latin. Even when we pronounce it incorrectly and don't really know what it means.
Just the Latin thing. People love it.
Yeah. So the Latin phrase is dolus or dolus, which means intent, and then we have what we call dolus directus, which means direct intent. I think we can keep that quite simple. I want to kill Max, and I kill Max. I had direct intent subjectively to do that.
Stingy word, the premeditation word.
Yes. Well, it's not to say that there's premeditation if there's direct intent, because direct intent can be formed in a split second. But the fact is, you wanted to achieve a certain result on a certain person, and that is what you did. Then we have what we call dolus indirectus, or indirect intent, which basically means you have the intention to do something in respect of one person, but it's necessary for you to also do it to another to achieve that goal. So let's say I want to shoot you, but you're standing far away and there's somebody standing next to you, but I don't really care, and I let loose with an AK on Otto, and I end up shooting 2 of you or 3 of you, or some innocent bystanders or whatever. I didn't necessarily have, I didn't have the direct intent to shoot the guy next to you. I had direct intent to shoot you, but indirectly I did have intention to kill him, because I did foresee that as a necessary result of achieving my actual goal, and therefore I had indirect intent.
Acceptable collateral. There was collateral. You were happy to accept the collateral that came with your direct intention.
The third form that intent can take is dolus eventualis, which is it's in a sense not that different from indirect intent, but essentially with indirect intent, you do foresee that something is going to happen, and you consider it as part and parcel of what you need to do to achieve your actual direct goal. Where with dolus eventualis, I actually have the intention of, say, shooting you, and I end up missing you and hitting the guy next to you. But I did foresee the possibility that I could miss you and hit another person, and therefore I had dolus eventualis. In Afrikaans, it's called moord by moontlikheidsbewussyn, of opset by moontlikheidsbewussyn, because you do foresee that there is a chance. And I think the best practical example of that is what ended up happening in Oscar Pistorius's trial. The court did not find that he actually wanted to kill Riva. It's an open question whether he did or not, and that's obviously the debate that's been going on ever since. But the court did find that on the evidence, it wasn't proven beyond a reasonable doubt that he wanted to kill Riva. In other words, that he had direct intent to do so. But the court said when he fired, 4 shots through the bathroom door, believing that there is a human being in there, he did foresee the possibility that he would kill that human being. So indirect intent or dolus eventualis can actually also apply where there's some form of let's say error in personam, a mistake with regards to the person that you think you are targeting, but you are still targeting a human being in the absence of a valid defense. So therefore there is dolus eventualis, and on that basis you still have the necessary intent needed to comply with the definition of murder, even though you end up shooting a specific person that you did not, according to you at least, want to shoot. But if it had been a burglar, for instance, in the case instead of Riva, the question is, would he then have been justified to shoot? And I think on the objective facts, the court concluded that no, he would not have been. And we'll deal with that when we deal with the definition of private defense. But there was a problem with proportionality, because you think there's somebody that has broken into your house and now it's okay for you to shoot the person.
I think this is a good time now, Francois, to unpack. Let's not delve now into the confusing realm of negligence on the other side of it. Let's stay in the intentional realm. Let's stay here. So let's say you've been attacked in your home, or there was a guy with a screwdriver standing in the kitchen when you came down to get a glass of milk, and you drew your firearm and you shot him, and he unfortunately expires, and the guy passes away where you shot him or close by. Now, let's say there's a bump in the night, and you also discharge your firearm using potentially lethal force, but there's an attack. There's a guy with a handgun. You've now used your firearm in self-defense. Let's unpack the factors and the defenses to charges of murder, because there's now a dead person. Somebody's death has been caused. And now the big question is it unlawful, and was it intentional? And let's have a look at that from a defense perspective.
Okay, so you could have on a charge of murder, I can basically foresee two defenses. The one is private defense, or as we call it in die volksmond, self-defense or selfverdediging. Noodweer is the proper Afrikaans word for private defense. Or you could have a different defense called necessity. And even though the word necessity means is quite a broad word, but the legal defense of necessity is something very specific. So you can't say you plead necessity when it was necessary to do something. It's a bit more complicated than that. But that's essentially the two defenses that you would be dealing with. In Afrikaans, it's called noodweer on the one hand, or noodtoestand is the Afrikaans word for necessity. So it's always a bit confusing that the terms in different languages aren't necessarily, textbook translations of the same word. But be that as it may, I think let's deal first, and we'll have to see how much time you have. But I think if we delve into necessity, it takes up quite a bit of time, and then we have to distinguish the two from each other. But I think let's start with private defense, which is what you would plead in most instances, especially as far as most of our viewers are concerned, who own and carry firearms for defensive purposes. So I'm going to give you a textbook definition of private defense. This definition comes from Professor C.R. Snyman, who is considered basically him, and there's another guy whose surname is Burchell. They are basically the two, I would say, leading authorities on substantive criminal law in South Africa, at least. If you go to any university, you're going to be using one of those two handbooks in criminal law. Okay, so the definition of private defense is as follows. A person acts in private defense, and his act is therefore lawful if he uses force to repel an unlawful attack which has commenced or is imminently threatening upon his or her or somebody else's life, bodily integrity, property, or other legal interest worthy of protection, provided the defensive act is necessary, is directed against the attacker, and is reasonably proportionate to the attack. So I know that's quite a mouthful, but essentially if we deal with the elements, I'm just going to look through the definition again and then say that the elements are the following. It's where you use force to repel an unlawful attack which has commenced or is imminently threatening, and it is aimed against your or someone else's life, bodily integrity, property, or other legal interest worthy of protection, provided that, so now you need to obviously go and limit the definition by saying, provided that the defensive act is necessary, is directed against the attacker, and is reasonably proportionate to the attack. All right, so I did use the word property, and we'll get to that specifically. And no, I'm not saying you can shoot somebody that takes your property. I'm saying quite the opposite. But it is part of the definition, and it remains part of the definition, that you can protect a variety of legal interests with private defense. That's not to say you can shoot someone or kill someone. If you assault me verbally and I defend myself verbally, I'm also using private defense. If you slap me and I slap you back, I'm also using private defense. If you try to grab my phone and I resist, I'm also using private defense. But the key here is proportionality. So we'll get to that. So please, I'm not saying that you can shoot someone who wants to take your property. I'm saying you can act in private defense to protect any legally recognized interest, which includes your property, but there needs to be proportionality between the unlawful act being perpetrated against you and the nature of the defensive act that you then aim against the unlawful attacker. And believe me, you're going to have a problem if you shoot someone who is stealing your property in the absence of an actual threat to your life or bodily integrity or something like that. All right, so let's deal with the elements quickly. The first important element is, I would say, that there needs to be an unlawful attack. All right, so you can, for instance, not resist arrest, assuming it's a lawful arrest. So let's say you did actually commit an offense that qualifies for arrest, and now the police officer is trying to arrest you, and you are resisting arrest, and now he uses force, and now you use force back at him, and you get charged with resisting arrest or with assault or whatever, and now you claim private defense because the attack against you is not unlawful. It's lawful because there's a lawful basis for it. All right. Another typical example is you cannot act in private defense against someone acting in private defense, because a person acting in private defense is not acting unlawfully. Like we mentioned earlier, the definition of murder requires unlawful killing. If you acted in private defense, that would be a lawful killing if the person ends up dying, and you cannot, therefore, let's say a robber tries to rob you and you try and shoot him, and then he shoots you and he gets charged with murder. There was no unlawful attack against him. It was a lawful attack. Or I don't want to call it an attack, but it was a lawful action, and therefore you cannot raise private defense. All right. So without complicating it, I think we can stick to that and say the attack against which you are attempting to act in private defense must be unlawful, number one. Number two, the attack must have commenced or must be imminently threatening. So I say to you, I'm going to come to your house tomorrow and shoot you. And now I decide to, you decide to come to my house tonight and shoot me before I can shoot you tomorrow. Then the attack is not imminent or has not commenced, even though I know you're going to say, but our police aren't necessarily very effective in this and that. The point is, you do have other options legally. You cannot take the law into your own hands and act preemptively. So a preemptive strike does not constitute private defense. And what I mean by that is preemptive in the sense of you are anticipating or expecting a possible attack, and now you launch a preemptive strike. You could perhaps, in a certain situation, if you reasonably believe that you are about to be attacked or about to be shot, you could, to a certain extent, act preemptively, but then it's because the attack is imminently threatening. All right, so it needs to have.
About to draw a firearm, we show him he's lifted his hoodie or his shirt, and there's a firearm there, and he's going for the firearm, and you shoot twice, and that
exactly. So the attack has commenced, or it's imminently threatening. He goes for a firearm, or he threatens you with the firearm,
urges towards you with a knife.
Or he says to you, I have a gun and I'm going to shoot you. Now, it all comes then down to whether you subjectively had an actual belief that it was going to happen. All right, but let's assume that all is present. So we've dealt with unlawfulness. We've dealt with the fact that it must have commenced or be imminently threatening. Also, it cannot be over. So I slap you and I walk away, and you run afterwards and you slap me back. That is not private defense. That is vengeance. Okay, even though I might very well deserve it.
That was the X matter. Do you remember that? There was a township matter. The guy was attacked, and he went home to fetch an axe. You remember that case? Yeah. And then he went to his attacker's home, and I think he dispensed justice with the axe, and he was charged with murder, if I have it correct.
I don't recall the matter specifically, but yeah, that would be a typical example of the threat was over. The threat was over, and he was now looking for vengeance or for punishment. And
See, a lot of, I think
defense
there's
is regarded as a defense. It's not regarded as a punishment or a form of retaliation or of
and this is
vengeance.
important. I think a lot of the guys or gals and people that carry or that are defensive carriers, the terminology that's used is always, I like to use the terminology potentially lethal force, and I always have. And I think it comes down to when you discharge a firearm into a person that's unlawfully attacking you, and you are obviously aiming for the central nervous system or for the lungs or for the heart or whatever it is to cause the most rapid hemorrhage, etc. The only reason you're doing that is because it's the most effective means to quickly stop the attack. That is why the training is on a primary organ basis, But the aim of the defensive act is not to kill the attacker.
It's to stop the attack. Absolutely.
It's to stop the attack. And that is a psychology that people should adopt in defensive. All circumstances don't necessarily call for potentially lethal force to be used. And that's a very important thing to note, that if I'm being, and we'll get to proportionality later, which is a very big part of it as well, but in this set of circumstances, it's important to listen to the legal definition of is to stop or repel an attack, not to cause that person's death. That is a byproduct of a defensive act, an unfortunate byproduct of a defensive act, if I could put it that way. But the aim is to stop the attack and not to kill. Sorry, it's just an important, I think a lot of people think that a defensive shooting, you're going out to, the consideration is to kill the attacker. It's not. If he runs away, or if he stops, or if he falls on the ground and drops his gun, it's done. It's over.
When the threat's over, you cannot act in self-defense or private defense any longer. Then we are in, let's say, a scenario where there's a legitimate attack, and you, at least at the outset, you are acting in legitimate private defense. But now the person turns and runs away, or he falls down, and let's say his gun has been, you've kicked his gun off to the side or removed it or whatever it is, and you now keep shooting at him. After it's clear that he poses no further threat, then you are actually exceeding the bounds of private defense, and you in yourself then become an unlawful attacker. And remember, as crazy as it is, technically speaking at least, your attacker is now entitled to defend himself to the extent that you exceeded private defense on your side. So that's in theory. I know in practice it could become quite difficult, but if I walk up to you and I give you a slap in the face, and you start beating me repeatedly, and as I fall down you start kicking me, you have exceeded the bounds of private defense, and now I am entitled to retaliate to that, even though I slapped you, because I slapped you, but you're not entitled to now kill me. So that also comes to the proportionality aspect. But all right,
so the proportionality aspect's a scary one, because it's the same question as the 6'7" cage fighter versus the overweight and tired attorney, in a parking lot at 1 a.m, there are serious considerations, I think, on that, on that front. But let's get there. We'll unpack that box when we cross it.
So the next element that I would deal with is that it must be necessary, and not to be confused with the defense of necessity, which is quite something different. But it must be necessary in the circumstances, meaning that you do not have another viable option. I've used the example of getting slapped by someone. Now, on the one hand, if someone slaps you and you slap him back, you could say that it's legitimate private defense, and if you didn't do it, you were worried that he would do it again. But practically speaking, you might ask, well, is it necessary? Do you have another option? And the answer is yes. The other option that you have is to walk away and to go and lay a charge against this person. And I know that comes with a lot of ja maar hierdie en ja maar daai en wat van dit en wat van dat. I know, but the fact is you need to ask yourself the question whether it's absolutely necessary, whether you have another viable option. And I think something important to cover under this point is we all know what castle doctrine means. That's basically a legal approach, I would say, to private defense, where in certain jurisdictions there might be a principle to say that your home is your castle and you are entitled to defend your property. In South Africa, we do not have per se what we could call castle doctrine. Castle doctrine in itself is not really a formal legal concept. It's just a term referring to a general approach of certain jurisdictions or certain laws that are
Certain
quite.
jurisdictions also have a sort of a stand your ground.
Exactly.
Principle.
You often hear people referring to stand your ground laws. Now, we don't per se have something explicit that says your home is your castle, or you are always entitled to stand your ground on the one hand, but on the other hand, we don't have any legal duty to flee, meaning there's nothing in our law that says you must try and flee. But you must accept that the necessity aspect, the requirement or the element that the Defensive Act must be, the requirement that the Defensive Act must be necessary, implies that if you do have a reasonable opportunity to get away or to flee, you must
if you can drive away, don't get involved in the shooting.
Exactly. And what you must also accept is that it's one thing what the actual test for private defense is. It's quite a different thing what a prosecutor is going to ask you in court. So you must accept that he will very well ask you, well, even that you were in your home and whatever, why didn't you run out the back door? And there might be a very good explanation to that, because my kids are in the house, or because if I did, I was going to end up being cornered there, or there was no safe escape route for me, or I considered the escape route to be potentially just as or more dangerous than rather facing my attacker, etc., etc. So, yeah, on the one hand, we don't per se have.
That's a very important point, Francois, because there's a lot to do with the psychology in these types of circumstances. I left the bedroom. Now I unlocked the bedroom door. I knew they were there. I saw them on the CCTV with their guns and stuff, and I left the bedroom and I went down the corridor, and I poised myself and got ready, and I essentially ambushed them in the corridor as they turned the corner. There's and I think it's a frank discussion that needs to be had. Is that psychology acceptable, and what kind of trouble would that get you into with the prosecutor?
Yeah, and look at also that there's kind of a overlap then between legality and tactics and all of that. So it can be quite complicated. And in certain defensive instances, the scenario that you now gave, you could, I'm sure you could justify why you actually then, let's say, confronted them, because your explanation might be, because I knew if I waited for them to meet me in my bedroom, I would be at a disadvantage. Because there's no way out for me. Tactically speaking, it might not be the best idea to leave your bedroom. It's an open discussion.
Yeah, and who says which school of thought is right? I suppose both have been effective in deterring attacks in the past.
Yeah. So I could most definitely foresee a scenario where you could explain away why you actually put on all your tactical gear and then gained the advantage and approached them before they could attack you. Because remember, there's still an imminently threatening attack. So it still complies with the requirement that it must be ongoing or imminently threatening, because you've already seen them busy coming into your property or whatever it is. On the other hand, if you had the ability to avoid the whole scenario, without having to confront these guys, or without having to have been confronted with them, you need to be able to, at the very least, explain why you did not take that opportunity. Dion, I'm not sure whether we have lost Max. Okay, it seems he is back.
I think he just went to put on his tactical gear.
Okay, he saw something on the CCTV. All right, so I think that more or less deals with the element that it must, or the requirement that it must be necessary in the circumstances, and I will then deal with
Sorry, Francois, just another one, and this is now again in the vehicle scenario. That the times that you're boxed in traffic and hijackers are about to hit the car and there's guns pointed at you and that kind of thing, this is always a very interesting one to me. And there's guns drawn, so I think we can accept that the glass window, the windscreen and the side windows of the car and the doors of the car are not adequate. There's a barrier between us, but the barrier is quite inadequate. So we can accept that there's an attack, right? The guns are drawn, the guns aren't out for tea, and the intention behind that attacker, moving towards the car, or rather that perpetrator moving towards the vehicle, is to acquire the vehicle. And I assume, or I can reasonably ascertain or deduct, that the firearms presence is to take my life if I don't comply or give him the vehicle. Now, there's certain considerations in that come into place at that time. Is the vehicle worth getting into a firefight in 5 o'clock peak hour traffic? That's consideration number one, because the second you draw your gun, you're now in a gunfight. It's not going to end in you walking away without exchanging fire with, these perpetrators. You've now made it a gunfight. Second question is the vehicle worth it? And I think the third question is, was there an option to escape in the circumstances by driving away? Again, there's no requirement in law for you to flee, but I think there is a requirement to exhaust the alternatives which don't end up in a firefight or in the shedding of blood potentially. That's the aim. So would you say that those are the considerations, whether you're boxed in or whether whether there is no escape route, you have to, essentially, and a big question I think a lot of people should ask themselves is it worth it for a car?
Yeah. Look, I'm a man myself, so I have an ego just like the next guy does, and I have, I think, a sense of justice and fairness just like the next guy has, and therefore it really irks me to think that people are hijacking cars and they get away with it, and it's literally a lifestyle for them, and they destroy other people's lives, etc. On the one hand, on the other hand, I don't think you'll be doing yourself a favor legally or morally or just practically psychologically by saying, I'm going to be Batman and I'm going to save the world from these people. And that's quite a broad debate as far as to what extent must you look the other way and try and flee, and to what extent must you confront people. I also do believe in the saying that the only thing that's needed for evil to prosper is for good men to do nothing. So I'm not saying that we should never stand up to evil or to criminals or to this and that, but you need to think very, very, very carefully before you decide that I do have an option to get away, but I'm going to choose to stay and I'm going to choose to engage because, like I say, there will be lots of consequences. Even in a best case scenario, thank God I've never had to do it, but I don't think killing someone is fun. Even when you are justified, even when you don't get charged, I deal with many instances where you have straightforward defensive shootings where the guy is never arrested, he's never prosecuted. It's basically, on the scene. We discussed last time how you deal with a post shooting scenario, but even in instances where on the scene the person is not arrested, at the very least, typically his firearm gets taken away for ballistics, and he sits without a firearm for quite a long time, which is a great case for a second defensive firearm, at least the second one. But in any event, where it's basically he goes home and he's asked to provide the investigating officer with a statement in due course, and he contacts me and we do a statement, and that's the end of it, except that he's waiting for his firearm for months and months and months. But be that as it may, he or she still deals with that psychological reality that
it's split seconds, bro. That's what kills me. That's what drives me mad, is that there are a billion things to contemplate, and there's a billion things that we worry about. From a lawyer's perspective, and our insight into reasonable conduct, good conduct. But myself, I've been in positions where you have split seconds to make a decision, and if that decision culminates in discharging your firearm into another human being, the consequences that flow from it. Never mind the fact that you're now in a gunfight and not everybody wins their gunfights. So there's a hell of a psychology that's attached to this, and I wish people would speak about it more frankly and with less bravado, or less, I think the horror of having to get into a gunfight with another human being because of the evil intention that they wish to exert on you. Yeah, I think it's stressful. Like you said, there's split seconds, and one must carefully consider it, but in split seconds, and it's
the
difficult.
reality is, in many scenarios, there will be some form of collateral damage, or there's at least a very big risk of it. So, as justified as you might be in the defense of shooting, you end up shooting a bystander in the process, and now you have to deal with that, legally and psychologically and whatever. So, yeah, I think let's leave it at that. But I'd say pick your battles, and a fight avoided is a fight won, essentially. It would be great if the powers that be would stand up to these people, so that we don't feel like we have to do it, because otherwise nobody's going to do it, and then evil will just triumph. But believe me, you're not doing yourself any favors by seeing yourself as a law enforcement officer or a Batman or anything in between. Private defense is also not intended for that. It's intended for a victim who has no other choice, essentially, or who has no better choice in the circumstances, and whose hand has been forced, if you know what I mean, as opposed to you going out looking for bad guys so that you can sort them out. There's space for that. If you want to do that, join your local CPF, and even then, remember that you are just a civilian. You don't have any powers beyond that, or become a police officer, or find a job in the security industry. And we are very thankful to those people who do that, because they do put their lives on the line, and they risk having to deal with all the, all that comes afterwards, depending on how these scenarios turn out for them. All right. So then the next requirement is that this, the unlawful attack needs to be aimed at your life, your bodily integrity, your property, or some other legal interest worthy of protection. All right. So you cannot, for instance, say that I shot someone because he said to me that I am a very unattractive individual. That your what would you even call that right? But let's say your right to decency, or to be treated decently, or whatever you want to call it, is not recognized. It is recognized, but not to the extent that you can perform a defensive act against it, or at the very least, not something out of proportion. Okay, so the starting point is you act in private defense because a certain right of you has been infringed, and that right is deemed worthy of protection. Now, your good name is, for instance, worthy of protection, and it is legally recognized, but you have many other remedies to protect your good name, rather than to assault someone who has just embarrassed you in front of anybody else. And the proportionality basically deals with the fact that even though you can act in private defense as far as a variety of your legal rights or interests are concerned, you can only do so in proportion. So you can imagine that it will almost always be out of proportion if you try and protect your property by shooting someone. Now, obviously, all of that depends on the circumstances. If I can use an extreme example, you might remember quite a few years back in, I think, Kulini is the town. I think it's somewhere in Western Transvaal, or in Northwest Province. There was a lot of unrest, and they were threatening to set people's homes alight, etc., etc. Now, In that instance, if you were to ask yourself the question, I'm standing in front of my house, everything I own is in there. Let's make it straightforward and say I don't have insurance over my property because I cannot afford it. And there's a person that says, I'm about to set your house alight. And in the scenario, the only option is for me to take defensive action, whether it be with a firearm or otherwise. Now, you might say that there's a bit more proportionality there than what there would be in the typical instance, but even then, I don't know how that matter would be judged at the end of the day. So, what I would suggest your approach must be is that it's not to say that the legal interest being attacked must be exactly the same as the one against which you are now defending. In other words, it's not to say they have to try and kill you before you could use potentially lethal force against the other person. But the moment that your life was barely in danger, obviously you have a problem with the proportionality already. Same with
yeah, this is now again, Francois, an important one just to draw the picture, if I could put it that way. But so a friend of mine on the farm, quite a remote area. Obviously, there shouldn't be passers-by that you don't know, etc. And he walked into his tool shed, which is a separate, tractor store. And he walked into his tractor store, and there was a guy standing there, obviously ransacking tools. There was a bag on the floor, and he was filling the bag with tools out of the tool shed. But in his hand, he had a screwdriver. This very large, plastic handled, but a very long flat screwdriver. And there was this sort of split second of them staring each other down. And this acquaintance of mine then drew his firearm, because he asked the guy, "What are you doing?" And the guy just sort of glared at him. And as he drew the firearm, this guy dropped the screwdriver and he ran away. Okay?
Yeah.
He ran for the hills. But I think the decision making in those split seconds is, okay, I'm not being attacked yet. I'm trying to figure out what's going on. But the circumstances warrant, there's a stranger. I've inquired as to what he's doing. He seems to be in the throes of stealing my tools. I don't know him on my property. I think it's reasonable then in those circumstances, or I submit that it's reasonable in those circumstances to draw your firearm. But he didn't point the firearm at him. The guy didn't answer, and he sort of started glaring at him. And there was a very little amount of space. I'd say 3.5 meters to 4 meters between him and, this gentleman with a screwdriver. So in the circumstances, I think his conduct was justified. Whereas, the guy dropped the screwdriver, happy ending, ran away. Okay. So obviously he was up to no good, but he wasn't down for
the drawing of the firearm in itself is obviously a defensive act. So if you, and let's say for argument's sake, he pointed the firearm as well. If he was then charged with pointing of a firearm, you could, let's say the guy still ran away, but he then laid a charge of pointing of a firearm. Looking at the proportionality, I tend to agree with you without obviously knowing all the finer details. But in theory, at least, that seems fine. You sit now with the tactical reality, however, or the tactical question of when you now draw your firearm, and you might be completely justified in drawing it or even pointing it, and that person now decides to indeed retaliate or not retaliate because you were
towards you, or advances towards you.
Advances towards you. Now, if he then advances towards you with a screwdriver, I would reckon that you are entitled to point him, and now it comes to the point where you are likely entitled to use potentially lethal force, because looking at the proportionality, there is an attack on your life potentially, or at the very least on your bodily integrity. But one must just keep
proximity, 3 to 4 meters. He's on top of you before.
Absolutely. But the point I'm making is you must consider the tactical reality, or the tactical question of when you act in exact proportion, which is fine, what will the result of that be on the other side? Now, in this instance, if the person then tries to continue to attack you, you are probably still, or attacks you, you are probably still justified, etc. But keeping in mind, not in this scenario necessarily, because you can't just leave his property and let the thief go on, because he is entitled to obviously take reasonable steps in proportion to protect his property. But you also need to consider in perhaps another scenario that somebody punches you in the face, you punch him back. What's that going to do? It's going to, so you end up with a life and death fight where it's not necessarily necessary because you could have avoided the fight. In this instance, the person would say, yes, it is necessary. I cannot abandon my property. Or wait for the police to come 2 hours later when this person has disappeared with a bunch of my valuables. So, yeah, just to get back to the proportionality, like I mentioned, that does not require that the attack must be exactly the same as the defense, meaning he wants to kill you and now you're going to kill him or something like that. But there needs to be proportion. So I wouldn't call it equivalence completely, because if you had to have equivalence, you would have to wait until you are almost dead or until he's already fired a shot before you could fire a shot. And that's not the requirement.
It's the thrust of a knife, or it's the pulling of a trigger, or it's
one
bad strike to the face and an artery under the.
And that's why, in theory, you could legitimately rely on private defense even when the attack was only imminently threatening but not commenced as yet. But yeah, it doesn't have to be the same weapon. For instance, you could use a firearm against a knife, or a firearm against a screwdriver, as in your example. But obviously, the court is going to have to look at all of these facts and say, okay, you mentioned earlier a big, strong guy and a tired, overweight attorney. So all of those things are looked at. It's typically a small, skinny woman would not get away with because she's the victim, but she would. The court would take a bit of a more liberal approach. Or lenient approach to the proportionality in that instance when she gets assaulted by a guy and after the third shot in the face she shoots him, whereas if I get hit by a woman in the face for the third time and I shoot her, that's something completely different, obviously. So the proportionality, in conclusion, does not require that it be exactly the same, but there needs to be a balance between the two elements. You look at all the weapons involved, the age of the persons involved, the gender, their own physical characteristics, the location of the defense, the potential harm of the attack versus the potential harm or the actual harm of the defensive act. If you say to me that I'm going to give you 3 slaps in the face, and let's say subjectively I believe that, and now I decide to hit you over the head with a crowbar, there's no proportionality between the harm or potential harm of the attack versus the harm or potential harm of the defense. So then you also run into a problem. So broadly speaking, there needs to be proportionality, and this is where we did touch on it previously. But
it's a proportionality of force and not a proportionality of weapons. People are inclined to fixate
exactly.
People are inclined to fixate on the tool, but
it's
a proportionality of intention. If you advance towards me with a sharp instrument or a blunt instrument or one that discharges bullets towards me or whatever it might be, I am entitled to act proportionately to overcome that attack.
And it's also proportionality with regards to the rights of both these persons. In other words, there must be proportion between the extent to which the attacker is going to infringe on your rights or potentially, and now the extent to which his right, you're not going to infringe on his rights because private defense is lawful, but the extent to which you are going to influence his rights or affect his rights by the Defensive Act. So that it's not to say you must wait, like I said, until you are almost dead before you can. But there needs to be an actual
nature of the attack deadly. Does that justify me using potentially lethal force?
Yes.
That's the thing. Subjectively, is the 6'7" cage fighter bearing down on me in the parking lot? Is it a life threat? And yes, potentially it is.
If you can say this guy was about to threaten my life or cause my death or cause me very serious physical harm, then there is proportionality for you to take action which say for argument's
Yes.
sake, ends up in the ending of his life. But if the worst, if it's somebody running into your shop and grabbing stuff, and you shoot him at that point, there's no proportionality, because your proprietary rights were going to be affected, and now his right to life has been affected. That being said,
Very well. I think that was well unpacked, Francois. I think that was a very crucial aspect is we don't need to say, oh, screwdriver versus screwdriver. So if the guy pulls out a screwdriver, it's not, more appropriate for me to whip out a pocket knife and now, get engaged in a,
you don't have to wait. That's also part of not of the definition per se, but I think if we unpack the requirement of that it's commenced or imminently threatening, you don't necessarily have to. Well, you necessarily do not have to wait for another person to launch the first blow. But depending on the circumstances, you cannot claim to act in private defense if you've basically hit a guy all over the face and you tripped him and you immobilized him on the ground, and by that point he had only said that I was going to eat you. if you know what I mean. So the last thing that I would like to just deal with is that I think I've dealt with all the elements or the requirements per se. As far as assisting other persons are concerned, like I did mention, you can act in private defense in protection of your own rights, essentially, or that of someone else, whether they are known to you or not. Practically speaking, obviously, you need to consider very carefully how far you want to go in protecting others, especially strangers. I think it goes without saying that there's a massive risk of error on your side as far as what you think is happening and what's actually happening. It's not always that clear cut who is the victim and who is the perpetrator. It might be that someone else is acting in private defense, but you happen to arrive right after the moment that someone threatened them with the knife, and you don't see that, and now this person pulls out the gun and starts shooting at the actual attacker, and you think now you are going to get involved. So as far as protecting third persons are concerned, be very careful, and remember also that afterwards, when the scenario is being assessed by people who have all the benefit of hindsight and time, then more questions are going to be asked of you, most likely, in a scenario where you got involved in a shooting between complete strangers, as opposed to where somebody was targeting your wife or your friend or something like that. That being said, legitimate private defense is legitimate private defense. So I'm not saying that there are additional requirements, or the defense only applies, or the more you know someone, the more the defense can be legitimate. That's not what I'm saying. I'm saying that it's more difficult to go and justify yourself based on all these requirements when you get involved as a third party, or as a bystander, or as a passerby, dealing also with the requirement of necessity, or that it must be necessary. Now, obviously, even though it's between people that you don't know, you can still comply with the necessary requirement by saying it's necessary not to protect myself, because I could just have walked past, but it is necessary to protect that person in the circumstances. But yeah, it's quite a conundrum that you are getting into when you get involved in other people's fights. I know sometimes it might be quite straightforward. You quite often see instances where one person protects another person, but it's one thing if it's a hijacker and you see the person in front of you at the robot being hijacked, and even then you need to decide whether you get involved in or not. But let's say you do, and that seems quite straightforward. But getting involved in a bar fight, for instance, is quite something different, because it's a he said, she said. And at the end of the day, you have that thing that I mentioned of you acting in private defense, but then exceeding the bounds of it, and then suddenly the other person's acting in private defense, and you just end up with a scenario where the waters are so muddied, if that's the right word, that you don't know your head from your toes. So yeah,
I think that really did unpack the private defense consideration. I don't know if we should address on a separate occasion the concept of necessity and
I think so.
culpable homicide.
I would appreciate if we could. I do have someone else to get to, but yeah, I think if we can deal next time with culpable homicide, that is essentially the unlawful, negligent killing or causing of death of a human being, and that's something that has quite a broad application. Everything from a scenario where you might, let's say, exceed the bounds of private defense, it could very well apply there. Or it even applies where you are in a motor vehicle collision and someone passes away and
being a pedestrian, being under the influence of alcohol,
something
that
like
could
that.
actually be as bad as murder, and
Absolutely.
yeah.
Absolutely.
So it's
and then necessity, I think we'll get into it next time, but a necessity I don't want to say it overlaps. It does have certain common elements and requirements to that of private defense. But necessity essentially deals with the scenario where, putting it in simple terms, you break a certain law to protect against an interest which is deemed to be more worthy of protection, or you infringe upon someone's rights because the right that you are protecting yourself against is more important. And we'll discuss the examples on the next occasion, but that's, for instance, where you exceed the speed limit because you're taking someone to hospital who is in critical condition, and then the state's interest or the state's right essentially to pass laws and enforce laws to protect society is in that specific instance worth less than this person's right of life. Or where you
attacking dog.
You shoot someone's dog, you cannot act in private defense against the dog because the definition of private defense requires that there must be an unlawful attack against you, and an animal cannot attack unlawfully because an animal does not have legal capacity. But now essentially you are protecting your life or bodily integrity, and you are infringing upon someone else's right to property because a dog is legally considered property. And let's say also is obviously there are certain emotional and emotional elements to it as well. So you might also be committing a delict in essence by causing that person anguish and whatever it is. So I think we'll deal with that on the next occasion. But I hope that private defense at least now is quite clear. And if anybody has
get to the hypotheticals, I can guarantee you. Yeah, there's tons of hypothetical questions that we've got to answer, and we will answer them. I think after we've gotten through the academic sludging and the heavy work, and then we can play the hypothetical game. It's always fun to tell people what we think reasonable conduct is, and that's.
But what do we know?
Depends on who's on the bench, But I think that was a very constructive session. And Francois, as always, thank you for your insight and time and the very collected manner in which you convey this type of information. It's refreshing and I think enlightening. And again, I think there was a lot unpacked today, so it's a lot to digest per episode. Dion, again, thank you for giving us the opportunity to continuously talk for long periods. We love it, and we'll pick up on the next episode.
Absolutely.
Guys, thank you from my side. I didn't have anything to say today, but very interesting. Thank you so much. I know your time is valuable, so we really appreciate the info that you give. And yes, looking forward to the next session. Thank you.
Thanks very much. Appreciate it. Francois, keep well. Dion, keep well. Cheers.